Good afternoon. My name's Marianne Wade. As I was just introduced, I'm a reader in criminal justice here at Birmingham Law School at the university. One of the things that I do in the law school is teach counter-terrorism law to our final year students. And obviously, in counter-terrorism law, in that course, we cover some of the most extreme powers that the UK government and its arms have to deal with extremely dangerous offenders and anyone suspected of being those. When I cover those extreme powers, one of the things I also like to do is to talk about some of the far less extreme powers that kind of get lost in that context. So I talk about Schedule 7 powers and what it would change of my life if every time or half the time I went close to a port or an airport, I would expect to be detained for up to 6 hours, and how that would actually change about what I value about my life. Now regularly, basically every year, a group of students approaches me then about that. Some of them are bemused, most of them are actually actively bemused, and they say, "Dr. Wade, what are you getting so excited about? That's just a normal part of life." As you can imagine, the students approaching me and telling me that fearing airports, fearing ports, or maybe wiping all the data off their phone and off their computer before they go anywhere near them are a normal part of life, are all Muslims or come from an ethnic background that they may be suspected and perceived as being Muslims. Particularly interesting in that context is how their fellow students who've been sitting next to them in lectures and seminars for 3 years react. They're horrified. They suddenly realise that their friends have a completely different reaction to, for example, the Holdsworth Society suggesting that they hop on a plane to Dublin over the weekend. And that in turn, that horror and shock that their fellow students demonstrate to them is also quite instructive for those students. So that's one thing that's really triggered me to think about citizenship. This completely different experience that students with similar educational backgrounds and in many ways similar backgrounds, distinguished only by one feature of the law school, have. Slides are not working. It is the other way. Citizenship is not an entirely clear academic concept. So there are some academics who would deny the idea that citizenship means anything more than nationality, the idea that that's all. However, I think it's fair to say that there is an academic consensus growing that actually the idea of citizenship encompasses something more. It's about an active membership of a community. It's about having responsibility within that community, but also having a voice, having the right to be heard, having the right to change that community, whether it's by voting or speaking. It's perhaps more reflective of that seminal idea of democracy that's ascribed wrongly to Voltaire, that I disagree fundamentally with what you're saying, but I would die for your right to say it. But in this idea of citizenship, there is also this idea that the state has a duty of care towards its citizens, that it has responsibilities that reflect that go with that responsibility the citizens also have. I think it has the potential legally to better reflect what it is we value about our lives, as those lives are also lived in communities. Now, I want to talk to you about citizenship, hopefully by making you feel very uncomfortable. If, like me, you're a person who believes that we live subject to the rule of law, but also protected by the rule of law, then some recent headlines and other articles in newspapers should be making you feel very uncomfortable indeed. Talk of the children of the Windrush generation, who, despite having lived all their lives here since they were small children, building their lives, having families, jobs, paying national insurance contributions and their taxes, were denied healthcare, denied their pension, declared illegal immigrants, and deported when they tried to claim them. The fellow citizens who died in the Grenfell fire, 72 people who burned to death in a building that they've been fighting for years to have their landlord recognise as inadequately protected. Those are the kind of things that must make us despair, especially when Grenfell happened in the richest borough of the country, that make us despair that democracy and law are serving some of our citizens badly. The key point for me, and that's of interest legally, is that these scenarios all demonstrate a separation of the exercise of executive power from executive knowledge and from that duty of care. So in case of some of the Windrush citizens, for example, an NHS finance manager can tell you whether or not, according to the Home Office rules they've been given, you're entitled to get healthcare. But they can't explain to you how that decision matches with the fact that you've paid national insurance contributions for 45 years, which legally you'd expect to give you a contractual right to it, actually. Now, this separation of executive action and the duty of care and knowledge is something that's more familiar to me in other contexts as a researcher. One of them I want to talk to you about is that of EU criminal justice. EU criminal justice has developed as a corollary to the freedom of movement we all currently enjoy within the EU. The idea is that no one should take advantage of that freedom of movement to travel across borders in order to commit crime and then to be able to withdraw back to another jurisdiction in order to stop the police and other law enforcement agents following them. It's part of that responsibility of citizenship. If we commit crimes, we have to take responsibility for what happens. The thing is that this area has then become associated with certain mechanisms, some of which you may have heard of. The most famous is the European arrest warrant. That is, the system is based on mutual trust, and the idea is that if someone in another member state, a police officer or an authorised individual in another member state, issues an arrest warrant, the police here will act directly on it, trusting that that arrest warrant has a legal basis. As you can see, in 2015, just over 16,000 arrest warrants were issued. So it's a mechanism that's used and it's regarded as successful. But the European criminal justice area also includes things like the European supervision order, which allows equivalent recognition of bail conditions, for example. Also the idea of transfer for punishment. So if someone's been convicted and sentenced to a prison sentence, they can be transferred back to the member state where they speak the language. So for example, they can participate in education and training whilst in prison. All of the things that we know help a person desist from a life of crime and live honestly once they're released from prison. The problem is that we can see that this area is quite unbalanced. It seems to be an area of executive opportunism, where certain governments are taking advantage of the ability to separate a sort of executive power away from a defensive one. They seem to be forgetting that particularly criminal justice systems are a reflection of a hard-won notion of citizenship. Over hundreds of years, we've developed the balance, and we've developed rules to make sure that criminals can be brought to justice, but also that people who fall foul of those in power can't be searched, can't have their houses searched, and certainly can't be detained without legal protection. Unfortunately, at the moment, in the area of EU criminal justice, we can have this legal fiction that actually a decision about whether you are tried in London or Sofia is basically equivalent to a decision about whether you're tried in Birmingham or Wolverhampton. But if you think about how we live our lives, that is a legal fiction and does not reflect how we actually do. The best way to demonstrate some of the problems of EU criminal law, and it's important to recognise that it is successful in many ways, is to show you a case. The most famous case example in this country is probably that of Andrew Symeou. Andrew was an 18-year-old who went to celebrate his A-levels with friends on a Greek island. For various reasons, which you can read about, he became accused of a murder of a fellow holidaymaker there. He and some friends were beaten up by the police, evidence extracted from them. After that, Andrew returned home, but the Greek authorities upheld the accusation and therefore an arrest warrant was issued against Andrew. I think it's fair to say that no one in this country who dealt with the case was convinced by the evidence. They all saw that it resulted from police brutality, and they were certain that Andrew was innocent and that actually the police should be looking for somebody else. Nevertheless, as you can see, Andrew was extradited to Greece, having fought that extradition. He was surrendered to Greece. Every British judge involved had to say, we have to trust the Greek authorities to sort this out. That's what mutual trust and mutual recognition means. Andrew then spent 10 months in a now notorious Greek prison in absolutely horrific conditions, but before being released on bail, and then spending a further 2 years waiting for trial. In 2011, he was cleared of all charges and allowed to return. But basically, the time that Andrew had planned to spend at university, he spent in prison in appalling conditions, or bound over in a country that he barely spoke the language of. The point here is, had Andrew been able to assert his citizenship, his right to be treated as a citizen, he could have had a completely different experience. So that European supervision order, had it been in force, could have allowed Andrew to be on bail in this country. It wouldn't have spared him the stress of a trial, but it would have allowed him to live something approaching a normal life rather than being in awful detention conditions. It's important at this point to remind you that the EU legislation has provided for these kind of liberty-securing mechanisms, but the British government has been at the forefront of a small number of member states actively blocking any liberties-protecting legislation. And if you look at the Security Charter now, Security Treaty currently being proposed, you'll see that none of them are included. So there's this idea of the European criminal justice area being used for executive opportunism. If you think about the image of justice, she usually has a sword and a shield in her hand. And I think that it's fair to say that on the EU stage, because of actions also by the British government, the sword is flying around whilst the shield remains firmly in the stone. The other area to talk about is counter-terrorism. And here the important thing to say is, of course, as part of our citizenship, we have to accept that there are dangerous situations which may require exceptional legal mechanisms. And counter-terrorism is doubtlessly one of them. The problem is, if this area is exceptional, it's strange that we've been subject to this exceptional legislation since 1974. And my point is also that counter-terrorism measures don't only affect those very dangerous individuals. So every year, there are a few hundred convictions for terrorist-related offences. But as you can see from these few statistics I've put up, counter-terrorism measures hit far more. So the Schedule 7 detentions at ports and airports, at their height of being used, affected almost 90,000 people. And still in 15-16, almost 30,000 people. Stop and search, at the height of counter-terrorism powers being used, when you can separate these out statistically, almost 110,000 people were affected by. Because of that, we have plenty of academic research which demonstrates that the effect of counter-terrorism measures ripples across what we refer to those who are members of suspect communities. My question today is it right then that my students stand in front of me and tell me that they don't know any different, that they don't know that as citizens they should be able to travel freely, not worried about the security services searching their electronic equipment or detaining them for up to 6 hours? Well, what does the law do? It's not true, of course, to say that the law doesn't do anything. We are protected by the European Convention of Human Rights and the implementing legislation. My problem with human rights legislation, and I'm broadly, I have to say I am a supporter, but I think that this concept of citizenship could do better, is because the European Convention is built only to protect this linear relationship between government and citizen. And as I hope I've already shown you, a lot of the decisions that affect our lives and the way we live them and what we value in our lives are no longer made directly by government, but by other instances who've been parcelled out parts of that executive power to make decisions, and who don't have that overview or that duty of care. The other point that I think is important to make is you can only make a claim under the European Convention if you are directly affected. And we don't live our lives only because and resulting from what we directly experience. We also live them because of what we anticipate. In other words, what happens to our friends, what happens to members of our community is something that we anticipate possibly also happening to us. And we modify our behaviour and we change our lives accordingly. In other words, what we value about our lives and how we can live them is affected by executive power far more than just when it so happens that the executive has done something to us. Also, human rights legislation allows you post facto to appeal against it. You have to be found, the government has to have been found in breach, and then you're entitled to compensation. What good is that to the kind of citizens I've been talking to you about? What good is it to the Windrush citizen who wants cancer treatment, or to the Grenfell victim who wanted a safe place to live? Particularly in a time of executive opportunism, this human rights system seems to be a little bit too impotent. The whole idea of citizenship and trying to incorporate a more muscular version into the law, I think, would help us to say that this kind of collateral damage is unacceptable. And those exercising executive power have to be mindful of it when they are exercising that power. Their duty of care means that if after 10, 15 years they know that the use of certain state powers are negatively affecting the lives of thousands of innocent people and their ability to participate as citizens actively in their community, then they should have to change what they're doing and not simply continue as if this is normal. We should all, at some point in our lives, enjoy the freedom to hop on a plane. The problem I think we're up against here is fundamental. As a law student, I always heard when we were talking about the anachronisms of the British Constitution, well, it's a bit weird, but it has been working for 800 years, and if it ain't broke, well, why on earth should we fix it? From my point of view, I think EU criminal law and EU criminal justice and the counter-terrorist arena are warning bells. And the point is that in these arenas, everyone should be treated as a citizen. So I'm not advocating less EU, I'm advocating EU citizenship meaning something in that context, the sword and the shield. I think Grenfell and Windrush, however, are something completely different. That right to make someone listen to you, to speak, is only valuable if you can make your landlord, make your police, make the Home Office listen to your argument as a citizen and take it seriously. After Grenfell and Windrush, the law and the Constitution has to change to protect our lives and the things we value. Thank you very much.